enter a plea of guilty or nolo. You may wish to enter a plea of not guilty, and while you prepare for trial, you can also look up that information.
All right, guys, buckle up. We're stepping into another wild courtroom moment. The judge starts things calmly, explaining plea options and giving the defendant every chance to act normal. But as you'll see, that calm won't last long. What begins like any routine hearing quickly takes a strange turn once the defendant opens his mouth, and his sovereign citizen side starts to show.
All right, DeMarcus Cantrell Brown.
Your Honor, we were representing him, but we are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah. For the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
aka Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes.
Okay, do you have someone in mind, sir?
I not right now. I'm seeking counsel.
Here we go. DeMarcus Bay. Brown makes his first appearance, claiming he's representing himself as a surety. The judge stays composed while trying to understand his jargon-filled statement. He asks for 30 extra days to find counsel, but it's clear he's already heading down a road paved with confusion. The courtroom's patience is about to be tested in full.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right?
The judge gives him a fair chance, granting time to find proper representation. But then he starts talking about affidavits of truth, insisting they haven't been rebutted. The judge calmly explains how real trials actually work: face-to-face testimony, not internet paperwork. This is where you can almost see the disconnect between real law and online fantasy growing wider.
Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness. Okay.
Okay. I got you. So,
all right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you.
Court cannot confer jurisdiction.
Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it'd have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have...
Wait. You see this book right here?
Now the defendant starts challenging jurisdiction, hoping to trip the system with buzzwords he barely understands. The judge doesn't flinch. She clearly explains that jurisdiction lies where the incident occurred. While he's trying to sound profound, she's just trying to keep him grounded in reality. It's the classic clash between confidence and comprehension.
This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not books.
Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
At this point, the judge decides it's time for a reality check. She pauses the nonsense and breaks down her years of legal training, reminding him it takes real education to understand the law. She even lifts up a massive legal book to prove her point. It's not just a lecture, it's a complete dismantling of his fantasy courtroom playbook, done with grace and authority.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So all right? It's not a difference between public and private for the record. There's no difference.
Sir, get an attorney.
Okay, all right. January 5th.
Yes, sir.
Okay.
And Mr. Bay/Brown, you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you're telling me United States codes don't work?
No, I'm telling you, you don't know them.
Got him.
So first of all,
right here.
The United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes, sir.
But according to 49.
Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m.
When he starts quoting Black's Law Dictionary, the judge shuts it down immediately, explaining it's not the law, it's just a reference tool. She stresses that actual attorneys spend years mastering real procedures. Her patience shines through as she turns this circus into a masterclass on why legal systems aren't built on Google searches or buzzwords.
So, DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
Is the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to stay and participate.
The defendant keeps pushing, demanding the judge prove jurisdiction and authority. But she holds firm, stating she's been on the bench for 10 years and doesn't need to prove anything. It's a calm but powerful assertion of authority. The exchange ends with her maintaining control, while his confidence slowly deflates in front of everyone watching.
Okay, who is the defendant in error? That's a new one for me.
The all-cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on, let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Mr. Bay.
oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state. Okay, Mr.
Yeah, no.
Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off mute.
Now, in his second appearance, the chaos doubles. He brings in his so-called Attorney General, who clearly has no idea what's happening. The judge tries to confirm credentials, but the man dodges with talk about being a foreign national. You can see her disbelief building. It's like watching a professional forced to referee a bad improv performance.
What's going on is he's a member of a foreign state corporation, basically doing business in Georgia. So
Okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying,
No, sir.
man.
No, and I get what you're saying, but we're not doing
I
that
know,
because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you
We
on
understand
the
the rules of the
calendar.
court. We understand the rules of the court. I got you.
Okay, are you a member of the State Bar of Georgia?
No, I'm not a member of the bar of Georgia.
Okay,
But what
then,
I'm trying to
no, then
realize
as,
he's doing business
then as
in way
he
in
can
Georgia,
represent
and that
himself,
you need to take consideration on that matter on how he's doing business in Georgia.
he can represent himself, or he can be represented by a member of the State Bar of Georgia. But he cannot have you represent him or purport to represent him. Okay? That's not going to work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I plead to be released.
That would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
Judge, you cannot practice law from the bench.
The judge, staying composed, explains that anyone practicing law in Georgia must be licensed with the state bar, no exceptions. Yet this self-proclaimed attorney argues he operates under a foreign state corporation. The tension rises, but the judge never loses her cool. It's a textbook example of professionalism versus pure nonsense unfolding live.
Violation on USC 454. Judge practicing law from the bench.
And put you on a trial court, on a trial calendar so that your case may be heard at trial.
Object.
All right, sir. Thank you. You'll get notice in the mail if anything changes about your address. Then you can go ahead and let us know by coming into.
I demand evidence hearing.
You will have that at the time of the trial,
evidence
sir.
hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is
you are dishonorable. I got your oath, Tammy Long. Hey.
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the mail.
You're in violation of Article 6, Section 2 of the Constitution.
Your notice in the mail, then you can appear for hearing with whatever evidence that you wish to present. Although you are not required to present any evidence or testimony because the state has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time. All right, Kevin Jermaine Burrows.
Finally, the judge lays down the law. He can represent himself or hire a real attorney, nothing else. He tries invoking his right to remain silent as a loophole, but she simply enters a not guilty plea on his behalf. The courtroom stands firm against his theatrics, and even through the chaos, you can sense the judge's steady control anchoring the entire